Welcome everyone to the next edition of the Parsons Centre Law and Business webinar series. We run these webinars around about once every month, and part of the purpose of these webinars is to engage with the broader business community and legal profession, particularly by sharing some of the fantastic work that our academic colleagues are doing, both here at Sydney Law School and also in other law schools. And the topic that we have tonight is a topic that's been certainly a lot of insolvency practitioners and a lot of insolvency lawyers have been thinking about this topic for some time. We'll be discussing the Indian Insolvency and Bankruptcy Code, which is something that I'm quite interested in, but I don't know very much about. And I just thought that the local profession, we've been hearing quite a lot about insolvency reforms in Australia. For those of you who are in Australia, because we might have some people overseas, there was a story in today's Financial Review where the Treasurer was saying that the Treasurer was being quoted in the paper saying that the federal budget is going to have some new insolvency reforms, expanding debtor in possession regimes, some further reforms for small business. So, these are not unique problems to Australia. These are issues that every jurisdiction around the world is dealing with. And I think it's really useful for us to be thinking about how other jurisdictions are dealing with these problems, particularly given that we seem to have a lack of detailed public consultation on these reforms. They get announced in the Fin Review and then rammed through the Parliament in short order. So I just think it's interesting for us to hear about the experience of some other jurisdictions. Now, before I introduce our speakers for tonight, just some housekeeping matters. So this, as all of these sessions are, is being recorded, and a copy of the recording will go out to everyone who's registered. That'll be sent to your emails, probably in the next week. We just do a little bit of editing and then send it out. It'll also be posted on the Sydney Law School's events page and the Sydney Law School YouTube page. So you can find all of our previous webinars if you just search for the Sydney Law School events page, and you can find, we've been doing these for the last few years now, and there's quite a few topics on insolvency, including international and comparative insolvency topics. If you do have any questions for our presenters, if you wouldn't mind typing those in the chat box as we go through, because there will be some time towards the end of the discussion where we can do some general Q&A. So if you have any questions, please post them into the chat. Our presenter tonight is Preeti Nalavadi. Now, Preeti is I think probably midway through your PhD studies now, or getting towards the end of your PhD studies now, Preeti?
Yes.
At the University of Adelaide, Adelaide Law School. She's been giving a number of talks over the last year on different aspects of Indian insolvency and restructuring law, particularly from a comparative perspective, comparing them with the experience that we've been having here in Australia. And no doubt she'll have some articles coming out on that forthwith. So Preeti's got extensive experience in this area and more broadly in banking and finance and in India. And she's going to share with us tonight some of her experience in that regard. There's been lots happening in Indian insolvency, including very recently with a pre-pack proposal that's been introduced into law. So we might have some time to discuss that. And then, as always, I like to have, where we've got an academic speaker, I like to have a practitioner as a commentator. And we're very fortunate tonight to have Betty Chen, who is a lawyer at Thomson Geer, working in insolvency in Melbourne. So thanks very much, Preeti. Thanks very much, Betty. And I'll now hand over to Preeti, who will tell us a little bit about her presentation tonight. Thank you.
Thank you, Professor Jason, for this wonderful opportunity, and thank you, Betty Chen, for your valuable time and being on this panel as well. And I thank all the participants who have made the time to log in for today's webinar. A big thank you to Sydney Law School for this opportunity, and Parsons Centre, as well as Adelaide Law School. The motivation behind this presentation is on this particular topic is my research that I'm currently dealing with. So my thesis is titled Revival of the Walking Dead. It's quite a scary title. I just kept it a little bit fancy there. And then comparative and functional analysis of 4 different countries on corporate rescue. So India, Australia, the United States, and South Africa. So Indian IBC, the short form that we call it, has been a very coherent part of my thesis so far. So in this particular presentation, the agenda that I would like to have here. So I'll just start the slideshow there from the beginning. So I would like to re-examine India's insolvency regime under the lenses of IBC and as well as the recent reforms that have taken place. So the agenda that I would like to have here is for this presentation is broadly speaking, I want to touch a bit on the historical perspectives, if I may say, because that would be really helpful and interesting for someone from another jurisdiction who would like to really know the background of it. And then the insolvency journey, what are the influences that might have taken place in as far as the insolvency law reforms are concerned, the other factors. I mean, I just took in bits and pieces which I found are highly relevant and highly influential there. Of course, because of the time constraint, we can't dwell much upon the historical aspects there because that's not the coherent part of the presentation. So on the IBC, of course, I would like to present on the IBC, give an overview how the working of IBC is and what are the intricacies involved in this code. Of course, my presentation will have good information on the recent reforms that have taken place under the insolvency regime in India, as far as the IBC is concerned, with an emphasis on the pre-pack regime that they are proposing to introduce, or they have introduced already, and a little bit of takeaway there at the end of it. So when we talk about India, we are basically talking about a colony there, an erstwhile British colony. And then it was in 1947 that India became free. And there was a lot of debate that after decolonization, that why we need to adopt the colonial ways. Let's go again in a different path. We don't need the colonial ways at all. And then let's try to understand and learn from different jurisdictions what suits best. So the lawmakers were very much into that, and then the Soviet model became a very important part of the governance structure, and they adopted the mixed legal system as well. So the first 3 decades post-independence has always been a kind of an era of serious regulations and licensing, I would say. And then when you talk about an insolvency regime or a corporate rescue regime, probably we found nothing significant as such during the British era, because although they had different legislations in place, like Presidency Town's Insolvency Act 1909 and Provincial Insolvency Act of 1920 and the Government of India Act of 1935. But whether there was a rescue regime during that period is highly doubtful, because they never had one that time. So it was post 1950s, I would say, between 1950 to 1980, which gained there's a lot of momentum there, lots of reforms happening in every area of law, including the corporate law or the insolvency, as well as the insolvency law as such. But even during this period, I would say 1956 Act, the Companies Act of 1956 has been extremely significant, because that had the chapter for revival and rehabilitation of companies there, which are in distress. So probably that can be a stepping stone. It can be a very important milestone there as far as a corporate rescue regime is concerned. But then there were other factors. So what led to this 1956 Act was the socialism that was in the paramount high. I mean, too much. I mean, in heights and there, because it all started with Pandit Jawaharlal Nehru, who was the first Prime Minister of India. He was so much drawn towards this philosophy, which he called as Nehruvian socialism. And then it was, of course, influenced by Lenin and Karl Marx as well. So it was all about institution building, higher education, health, and safeguarding local businesses, strengthening the public sector, investing more into that. And then, so this particular regime had not yielded the result that it had aimed, actually, unfortunately. But the seeds for socialism were already sowed, due to which Companies Act 1956 it's one. The socialism has been a very significant part of this particular enactment. It has been a very major factor, I would say. But then there were planning commissions, and there were the bank nationalization in 1969 as well, which kind of these are the influential factors that influenced the lawmaking process as far as India is concerned. But then post 1990s is something, 1985 onwards, I would say, because in 1985, Sikh Industrial Companies Act was enacted. So for the first time, there was a specialized legislation under SICA, wherein they identified certain class of industries. There was a list like which are the eligible industries that would be covered under that. And then the concept of sickness had stepped in there. And that was the time where, under this particular enactment, a particular industry would be identified as whether it has shown the symptoms of sickness, which was defined under the Act. And if it was sick, then the proposal of revival or rehabilitation would set in. And then there would be a board constituted, and it would have committee of creditors and all that stuff. And if it is found viable, the particular business would be revived. So it was, in theory, really a good law, I would say. And then Goswami Committee was quite instrumental in enacting this particular law. But then whatever the empirical data shows that nothing much was attained by SICA, unfortunately. And then there was again another committee which said that SICA had not achieved its result and it has to be done away with. So then was a big question arising. Now there's a gap here. So there was a big question arising, then what we do next. So then we had the SARFAESI Act coming in picture there, as well as the Recovery of Debt due to Financial Institutions Act of 1993 as well. So SARFAESI Act, it's the abbreviated version there. It's a Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act of 2002. It gave full powers to the secured creditors. It has nothing much to do with, as far as rescue is concerned as such. Of course, there are certain provisions which deal with that there, but then it's more like a weapon to the creditors for enforcing of securities. So it gave full teeth to the creditors, like they can issue demand notices to the defaulters, and they can take possession, and then they can manage the affairs of the company as well, and they can also have sale by way of auction, e-auction, and calling for bids and all that. So complete autonomy was given to the creditors, and bare minimal intervention or approval of the courts are required for this process. So hardly there is any avenue wherein they can knock the doors of the court. Of course, in India, we have the writ jurisdictions always open for the High Courts and the Supreme Courts under the Constitution of India, which is always a bit of a problem as far as the specialized laws are concerned. So that goes without saying. So when the SICA failed, there were lots of committees. Due to the paucity of time, I thought it's not important for us to get into all those committees here. So I just highlighted the important ones, which I felt was Goswami Committee, because they were the ones who were talking about the industrial sickness there. But then they also said that SICA has not been achieving the desired result. So that already had set in, that kind of philosophy had already set in there. But then there was a proposal that why do we have a specialized enactment? Why can't we bring in these kind of provisions under the Companies Act itself? But then that was, there was an exercise made on that, but that did not work well there again. So till 2014, nothing very significant actually happened as far as corporate rescue is concerned. So 2014, the Justice Viswanathan's commission, which is also called as the Bankruptcy Law Reform Committee of 2014, that has been a path-breaking committee, which gave fantastic report and said that, and they have examined different jurisdictions across the world. For that matter, even the previous committees had done that, but because of political will or some other factors, probably there was no effort made to have a specialized legislation. So for the first time in 2016, Insolvency and Bankruptcy Code came in picture there. So before we get into the Insolvency and Bankruptcy Code of India, I thought it's important for us to know how the debt resolution actually takes place as far as India is concerned. So this is a kind of a flow chart, which is quite helpful. But let's be mindful here. I would just want to give you a heads up that not all of these mechanisms are in place as of now, but this is just giving us an overview of the evolution of the debt resolution mechanism that has been taking place since 1985. So like you can see the corporate debt restructuring happening there. You can see the strategic debt restructuring and then flexible structuring of long-term loans. So JLFs and SMAs. So different kind of restructuring mechanisms that are governed under the Reserve Bank of India rules. India strongly adopts the London approach there as far as debt resolutions are concerned. And then these have been they have always been governed under the Reserve Bank of India, and there has been lots of improvements and changes that take place as far as these guidelines are concerned day in and day out. So that's another part of it. Coming to the IBC per se, so what is it all about? So for the first time in the history of Indian laws, there was a specialized legislation which actually dealt with all these three concepts: insolvency, bankruptcy, and liquidation. So as far as insolvency is concerned, they use this terminology to talk about the corporate insolvency. As far as bankruptcy is concerned, so that is the personal bankruptcy that they're talking about. And of course, the liquidation, the similar definition goes ahead there. So that's why they call it as a Insolvency and Bankruptcy Code rather than any kind of act or any other name, because they said that this is like a compendium of laws. So that's why they brought everything under one roof there. In a nutshell, it has 255 sections, having different parts there, 5 major parts, and it covers all kinds of corporate enterprises, limited liability partnerships, partnership firms, and individuals as well. But the process for the corporate debtors as well as the individuals and partnerships are a bit different there, because as far as corporate debtors are concerned, the adjudicating authority is the National Company Law Tribunal, called the NCLT, whereas for the individuals and partnership, it is the Debt Recovery Tribunal, which was constituted under the Recovery of Debt for Financial Institutions Act of 1993 that I previously mentioned in one of the slides there, where the creditors regime had already begun post 1990s. So that particular tribunal has also the jurisdiction for exercising power under the Insolvency and Bankruptcy Code as far as partnerships and individuals are concerned. So the NCLT will deal only with the company debt. The ecosystem, so you can see there are lots of players involved in this. So we have the Insolvency and Bankruptcy Board of India, and then we have the centralized repository of financial and credit information. So this is a kind of a problematic area, I would say. This is a third party. These are the third party organizations who are holding the credit information or different kinds of vital information about the borrowers, about the corporate debtors, and they are the ones who are sharing the information with the creditors or with the NCLT or with the board or with the resolution professional as well, once the resolution professional is appointed. So we also have the IPAs. IPAs are the professional bodies which are registered by the board. So they are those who are governing the resolution professionals here. Even the board is also framing different regulations as far as the resolution professionals creditors are concerned. And then, of course, the adjudicating authority is the NCLT, National Company Law Tribunal. We have the appeal lies with the NCLAT, the National Company Law Appellate Tribunal, and then the final appeal lies with the Supreme Court of India. As far as the corporate insolvency resolution process under the IBC is concerned, in a nutshell, this is the way it looks. This is the framework, I would say. So an interesting part and then an important part for initiation of a CIRP is a default. So until and unless there is a default, there cannot be an application before the NCLT as far as IBC is concerned, which is pretty much different when you talk about a US regime or any other regimes there. Another contentious part here is financial and operating creditors. So they have two different definitions for financial creditors and the operational creditors. And then operational creditors, financial creditors are mostly the secure creditors. I would give the example of the secure creditor there. Whereas an operational creditors, they would be the workmen or the employees or other creditors there. But the problem here is when you look at the committee of creditors, they consist of the financial creditors only, which is highly debatable till today. So other stakeholders like the employees, or the workmen, or the unsecured creditors, so they hardly have any say as far as the committee of creditors is concerned, which is actually a concerning issue, because I was sitting in the shoes of a secure creditor for a long time, and we already have enough teeth to enforce our security. And then, this is just adding new teeth to the secure creditors there. So then you have a resolution plan, and 75% of the creditors have to approve it, and this entire process has to take place within 180 days. It can be extended to 270. And then initially there will be an interim resolutional professional called the IRP appointed, but then afterwards the adjudicating authority can decide if they want to continue with the same person as a resolutional professional, or they can also have a change there. For debtors, so the resolution plan will basically have the payment of a resolution process of the costs, and then there would be how the claims are going to be managed, and then there would be the list of those claims as well, and then the management of the affairs of the company after the plan is approved. So it rests with the resolution professional there. So once this process has been initiated and the moratorium applies, then the board of the company is automatically dissolved. So now the powers vest on the management of the, as far as the management of the company is concerned, is now vested with the resolution professional. So resolution professional is a powerful entity, is a powerful person as far as Insolvency and Bankruptcy Code of India is concerned. So there's a lot of debate and a lot of people writing about it, especially, of course, we don't have much of academic scholars writing about it, unfortunately. I would be really glad to read those things. I'm waiting for them, but can't find any. But then, of course, there are people who are in the industry writing about it. There are organizations like EW or PWC and those kind of people who are coming up with empirical data and some kind of reports there which are helpful. So it has been a mixed bag. If you look at the number of cases that have been dealt with over a period of time and what is the success ratio and all that, it has been a mixed bag. Of course, there has been large corporate debts that have been resolved in this mechanism. For the very fact that the secure creditors, especially the public sector banks in India were completely excited about this new legislation, and they were the first who in queue to file claims, to file applications under the IBC. And in fact, I would say this IBC, the revival and rehabilitation, or helping the business to work in a better way, to make it more viable. Whether they have been actually doing this, that has been the objective of this act anyways, but whether that has been happening, or is it only working like any other debt recovery mechanism, so that's for introspection, and I really want to work towards that in a deeper way. Unfortunately, I can't see any evidence for that. It's only working like a debt recovery mechanism. I mean, whenever a secured creditor is filing an application, for the sake of it, to have some kind of a pressure built up on the corporate debtor, because the management is anyway going to be dissolved and the RP will come in picture. So for the fear of that, there is settlement happening and there are other things happening there. And then that's the major issue going on as far as the large corporate debts are concerned. So probably because of that, some of the debts have been settled, I would say. So the challenges have been, you have seen different, I showed you the slide where there's an ecosystem of different players involved there. So how do we manage these players and how do we manage the dynamics between this? The relationship between these players has been a major concern because India had never had this kind of a regime before. And so this is a kind of an infrastructural lack of training, lack of understanding of this new law. So that has been very, very challenging, and it has been a learning process so far. Lack of precedence as well. So that's also another problem with different NCLTs in different jurisdictions interpreting on the same thing in a different fashion, in a diverse way. So these are the technical problems that are arising there. So it's really very early to say that it has been a successful regime. As far as it, and also other factors like the time factors in the IBC. So it says 180 plus, it can be 270 days maximum. So within 270 days, everything should happen. So that itself is a extremely challenging thing as far as India is concerned, because with the number of courts on NCLTs are less, and there are lots of other cases there coming up there. So I just read the EY report recently, just 2 days ago, wherein they said that 13,000 cases are pending so far. And then, well, most of them are like there is another data that they say like 41% of them have already exceeded the time limit there. So that's another problem, because when it's like 41%, it can also increase, because if you look at other laws and the way other things are enacted there, that has been the precedence. So that's another problem. So I would say that it's surely a mixed bag. Insolvency reforms that have taken place recently. So this is one of the most important reforms they have done so far, I would say. There have been lots of reforms going on, especially during COVID crisis, where they had some temporary moratoriums in place, and then all those things. I mean, the tweaking of the IBC was happening just like any other jurisdiction due to the pandemic. But the most significant one has been the Insolvency and Bankruptcy Amendment Ordinance of 2021, which was introduced recently with the effect of 4th April 2021, wherein that was a result of a report of a subcommittee that was appointed under the leadership of Dr. Sahu. Here they came up with the idea that why not we introduce pre-pack system in India. So because they had a study of different jurisdictions like US and UK, and then they said that this can be a game changer as far as Indian corporate rescue is concerned. So why not we have that? Probably because the targeted borrowers were from the MSME segment, it is a kind of I would say a delayed response to the World Bank report on MSMEs, because the World Bank had already come up with the report in 2017, but it took a while for India to introduce the pre-packs. Anyway, now that pre-pack has been done, it's worthwhile to see how it's going to work. The motto behind this is to ensure quicker, cost-effective, and value maximization. So whether we are able to achieve that is the big question that I want to pose here, because so they broadened this new concept by way of an amendment in the IBC by introducing a specialized chapter 3A, and they call it as a pre-packed insolvency resolution process in short called PIRP. So is India ready for this shift is a big question, because so far they have always had a creditor in regime. I mean, creditor in control, I would say. I don't think people might be using that kind of a phrase, but I'm really happy to use that because I can also have evidence to substantiate that claim. Creditor in control. So even when SICA was introduced, it was the creditor who was controlling the board. Even for that matter, the other debt resolution mechanisms, the flow chart that I showed a couple of minutes ago, even in those situations, it's the creditor who is in control of the negotiations there. He has an upper hand, he or she. I mean, we're here as well. In the IBC as well, if you look at the creditors committee, again, it's creditor in control. So now they are, with this mechanism, they are saying we are now going to introduce something called as a DIP model, debtor in position. So how is that debtor in position is it's quite tricky there, and I'm not sure why they call it. Maybe because they were very excited to look at the debtor in control position of Chapter 11 of the United States, and they said let's have it and let's make a path-breaking kind of a revolutionary kind of mechanism. But then that is unfortunately that may not be true, I'm afraid. So of course, it's an alternate revenue for MSMEs. I think the goal is really good. The objective is really good there. And then, but the problem is it just another mechanism added in the already complex system of IBC? Just another level there, another layer. So how is that going to work? So they introduced a section called 11A for this purpose. And so PIRP adjudication has to be completed within 120 days, unfortunately. And if CIRP has already been filed, then probably the question of PIRP will not arise then. And then again, there is a trick as far as moratorium is concerned. I will come to that in my next slides there. So this is a kind of hybrid mechanism where they are trying to mix and match some informal mechanism as well as formal mechanism there. But again, like I would say, why will the creditors buy this? So I'm sure Professor Jason Harris will like that. What is the incentive for this? What is the incentive for the creditors? So that is a question. So I just prepared a bird's eye view for this entire process. So there has to be a minimum default as far as the corporate debt is concerned. And the minimum default can be USD 13,000 in Indian currency, like 10 lakh. And these are the main, the two green slides that like shareholders have to approve in a general meeting, and the financial creditors up to 66% at least minimum. So they have to approve this, and they have to approve the base plan as well within 2 days to be filed there. And after this approvals, the adjudicating authority has also to approve them. So the adjudicating authority will approve, and then the adjudicating authority will either approve or terminate. So what happens after that? So I'll come to that in the next slides as well. But if all the approvals have been done, then at that particular time, the moratorium actually begins. So here is the trick. So what happens in this gap period? Is there a moratorium? No, absolutely not. There is no moratorium as far as this gap period is concerned. So that's another problem there. So then within 7 days of the corporate, within 7 days, the corporate debtor has to file the claims before the resolution professional with the base plan and the information memorandum, the IM that they say, which includes all the asset liability and various other details of the company there, as well as the claims. And then the COC is constituted, Committee of Creditors. And the first meeting has to happen in the next 7 days. So if you look at the timeline there, 7 + 7, 14 days, it's absolutely, I would be really surprised if they come out with some success stories there, because they have to get all these approvals done, and then they have to come up with the creditors committee and then start the first have the first meeting as well. So I'm not sure if it's practically viable, but then it's yet to be seen. So the controversial part I would say here is when the resolutional professional submits the plan to the adjudicating authority, within 90 days, they have to submit the plan. Otherwise, the entire process terminates. So it's basically their aim is to have a time-bound mechanism. I totally appreciate that. But if you look at the previous records, or if you look at the previous regimes that they have been having, so how are they going to achieve it? So is there a plan in place for that? So that is something which is tricky and which is unanswered so far. And the absolute power of the adjudicating authority. So here the adjudicating authority, the NCLT, can either approve or reject the plan. So ultimately the power rests with the adjudicating authority to approve or reject the plan. Again, we are at the mercy of the NCLT again. And let me just give you a heads up that NCLT is not only exercising its power under the IBC, it's also exercising its power under various different laws as well. So it's already, and we are talking about an overwhelmed NCLT system, which has 16 plus NCLTs across India. So how does it going to work? So consequences of termination, it's quite bizarre. That's why I made 3 different boxes with red in color there, because those are the bizarre ones according to me, in my opinion. So if, of course, the green box, if it's successful resolutional plan, the DIB remains intact. So basically during this entire process, what they're saying is the debtor will continue to run the management of the company. So it's not going to be disturbed, but under the supervision of RP. So how is that dynamics going to work there? So supervision of RP is here to stay. But having said that, then they say when the PIRP is terminated, or there can be, even before the termination at any point of time, if in the opinion of the committee of creditors, or if in the opinion of the resolution professional, if there has been some dodgy thing happening with the debtor, management of the debtor's company, they can anytime switch it from a DIP to CIP. So DIP, debtor in possession, to creditor in control, creditor in possession. So immediately the creditors take control of this entire, the management of the company, which is completely, I mean, it's going on the other side there. And it's, again, you are at the mercy of the committee of creditors. And then again, you are at the mercy of the resolution professional. So they are there to decide once again, along with the adjudicating authority. So mandatory liquidation. That's like, I mean, if it's PIRP is terminated, of course, there can be a CIRP after a PIRP. That's quite possible. But then the adjudicating authority can order for a mandatory liquidation. So are they really doing the right thing? I'm really concerned about this particular aspect as well. And then bar from another PIRP application for the next 3 years. Probably this is one way they want to control people coming back again and again, and to take care of their overwhelmed national company law tribunals. Probably that's one way they wanted to filter those kind of people, and they have brought that thing in place there. Problems with the PIRP. Yes, so lots of problems, I would say. Just to mention a few here. Approval of AA is a must in all stages. So the power given to the adjudicating authority, the NCLT, is really huge. So how do you call it a rescue mechanism? How do we call it? I mean, how the interest of a corporate debtor is being protected? What kind of autonomy is given to this corporate debtor? Even when you say it's a DIP model. So that is a bit problematic there. And 120 days, again, the timeline and how, because they have, earlier, we have lots of precedents to show how in different enactments, including the SURFACE and various other legislations, including SICA, wherein timelines have never been actually followed by the courts. So how is this going to be different is the question. Too many approvals at various levels before initiation of PIRP. No moratorium in that gap period. So during that gap period, a creditor can always initiate an action. So how does this process protect that? So until and unless the base plan is approved and all those approvals of those committees, those players have been done, then only on the commencement of the PIRP process, then the moratorium starts. But till then, that gap period is as it is. So creditors can have their process done there. Creditors have no incentives to buy this particular mechanism. Why should they get into the hands of the appellate authority? The adjudicating authority again. They have different mechanisms wherein they are in control of the entire process, especially the SURFACE Act that I was mentioning, as well as the OTS. Here, OTS means a one-time settlement. That's a kind of a debt resolution mechanism. The previously shown that chart that I mentioned based on London approach. So there they have different mechanisms that the Reserve Bank is already prescribing. So why would the creditors, they completely enjoy an autonomy there. Why would the creditors want a PIRP is a question, because that's something which probably would not be their first choice at all. And a DIIP feature becoming a CIIP anytime, meaning the corporate debtor walks on sword's edge. Yeah, because anytime this particular model can change, the management can shift. So which is again, why would again a corporate debtor would file an application for a PIRP is the question again. Because the moratorium anyway is not going to start quickly. So instead of PIRP, probably he would like to file a CIRP, because CIRP can be filed by the debtor company as well. So in that situation, why would, he would go to that because at least he has a lot of time as far as CIRP is concerned compared to PIRP. So PIRP is so much time bound, like in 120 days, you have to do lots of things. And then if it doesn't work out, the management may change, or it can go to a compulsory liquidation. So at least in CIRP, he has some timeline, a bigger timeline there, a bigger slot there. So probably he can approach the CIRP regime and not get attracted to this. And why would they get attracted is the question. Transplantation of laws from other jurisdictions. So I always refer Natalie Martin, where she says that it's a dangerous game. So just because someone else has enacted a particular kind of law, will that suit your system? So how does this work? So the way ahead is, it looks like the PIRP is here to stay. So that's not going to go so quickly because of the MSME. It's now the governments and as well as the lawmakers success kind of a thing that they have made a legislation or separate mechanism for the MSMEs. The target audience is the MSME there. So probably it's here to stay, but it will evolve over a current period of time. It's going to be ever changing, which will be interesting to watch. And with the challenges that are here, especially the pandemic situation, we are yet to see how this is going to work there. But an interesting thing is, in the last financial budget, the finance minister, she came up with a proposal that they are thinking about forming an asset management company, which they called ARC in India. So that is enacted under the that kind of a company, the asset reconstruction company, they call it, is constituted under the SURFACE Act, the act that I mentioned previously. So this is going to be a bad bank under the public and private partnership there, and that bad bank is going to buy bad debts from different lenders and then try to convert that bad debt into equity by attracting investors across the world. So that is quite an interesting thing. It was always in place in the sense there were private players so far, We never had a public-private kind of a partnership wherein the government of India is involved. So that kind of a thing was not technically there as a rampant kind of a thing. But here, the government of India is clear that they are not going to invest in this directly, but they are calling for some public, some other public sector or bank would maybe try to rope in that one and have a private player as well and come up with the bad bank. So as far as the Indian Bankers Association is concerned, they have welcomed this idea because this was a recommendation they had in place, and they were always debating that we should have a bad bank. So it is now we have to see how this is going to culminate now. Thank you very much for this one. And if there are any questions or comments, I'm extremely happy to take those. And then I have also given my email ID for anyone who is curious to know more things, or if they want any kind of a literature or any kind of a resource that they are interested in. I'm really happy to respond to them and share those things with them if they like.
Thanks so much.
Thank you very much.
That was fantastic. You covered so much ground. The flowcharts were fantastic. I've certainly learned a lot. I might just throw over to Betty to offer a local Australian insolvency lawyer's perspective on this, and then we do have a number of questions that we'll come back to in a moment.
Thanks, everyone. Thanks, Preeti, for this detailed presentation. It's amazing. Thank you. Now, basically what I want to say is, I won't be long here, is that in Australia, obviously, we have a totally different model compared to India. In India, as Preeti has gone through, that they have authorities who can make decisions and, have a lot more detailed process actually involved. Whereas in Australia, a lot of it's coming from, say, for example, our restructuring option. This is something to do with the voluntary administration, where the company will just simply enter into a deed of arrangement or a resolution by creditors. The creditors obviously not going to be in control of the company. So I was very surprised on that note that India have taken that approach. Obviously, the next step, I don't think that in the current environment, there are a lot of liquidations. Actually, the process is actually happening, but from a academic point of view, I believe that the liquidation process is also quite simplified as well, because there are three types of liquidation. There's members voluntary winding up, creditors voluntary winding up, and compulsory winding up. But all these types of liquidation is not something that needs approval as such compared to the lengthy approval in India, but it's more to do with it's a process where the assets of a company are collected and released by a liquidator. So the liquidator in terms of having that control of the whole process in comparison to India. So I think in terms of a practice, it's very, very different. To start having to, go back to the very beginning, how the company become insolvent is with issuing a statutory demand under Section 459E of the Corporations Act. So I think, in India, there's a lot more process and a lot more, things that needs to go through compared to Australia. And it's quite interesting. That's all I have to say from the Australian insolvency point of view.
Thanks very much, Betty. I think there are some similarities here. One thing that really resonated with me while you were speaking, Preeti, was the idea of this new PIRP, and is it really a debtor in possession? It seems like the government is kind of entranced by this view of Chapter 11, and it wants to say that it's doing this sort of thing in India. I see a lot of similarities here in Australia with the new Part 5.3B, the small business restructuring regime. I've made a similar criticism of that procedure where it's called debtor in possession, but then there are limitations on what management can do. The restructuring practitioner might need to approve quite a lot of things. So I can see some similar issues there. One of the things I think is quite interesting is the idea of embracing pre-packs. I mean, it's something we've talked about in Australia a lot. It's something that happens, say, in creditors' voluntary liquidations, just building on your point, Betty, and there are firms around town who are kind of promoting what they call lawful pre-packs, which effectively is just negotiating an asset sale prior to the liquidation. The liquidator still will often run a public sale campaign, although if it's a small proprietary company, putting an ad in the Fin Review and that's ringing up a few potential buyers, that's probably a public sale campaign. So the volume is also an issue, and that's something we haven't really dealt with here. With the small business restructuring procedure, the government wanted it to start on 1st of January. And the idea that, we'll have a separate class of liquidators, but we won't prepare all the rules in advance yet, and really kind of trying to develop the policy on the run, as it were. There were some predictions last year in Australia that we might have potentially hundreds of thousands of businesses needing to go through insolvency post-COVID. That certainly hasn't happened. And while we're seeing a reasonable upswing in economic activity, I'm not sure that we can say that all of those businesses that were in financial distress last year all of a sudden are magically better now. I do wonder whether a large number of those are simply on life support still, because our banks fortunately have such strong balance sheets and they can drip feed some of these businesses along, or have effectively been abandoned, and that poses its own problems. How do we deal with the kind of corporate underbelly is the wrong word, but it's that kind of low asset, no asset business. And I suspect there's an awful lot of those in India as there are in Australia. We have a very complex insolvency system, as you seem to have presented here in India. And all of that comes with a cost, and restructuring practitioners and insolvency lawyers don't work for free, nor should they. And the question is whether we've got that balance between the cost and the expectations right. Are we imposing a system that just has too many checks and balances so that effectively it doesn't work as efficiently as it could, and we're getting suboptimal outcomes? And that's the concern that I have for our system. But that's really been just a tour de force of the Indian regime, Preeti. I really appreciate you taking the time to take us through that. I've certainly learnt some things there. We do have some questions. So Preeti, I'm not sure if you can see on your toolbar there, there's some questions.
Yeah. I can see that as well.
Wonderful.
So I just to add to your review as well, time and costs. That's again a major issue as far as India is concerned as well. So if they are doing certain things where they are not even considering the time and the costs that are going to be in place, so probably every such change in the law is going to be futile, because I don't see any ray of hope if they're not even considering that, because especially the PIRP that they brought in. So it's the same with the CIRP as well. The costs and the time factors are surely there, and they are the concerning areas, and it's going to be the same with the PIRP. That's the major concern I have.
Yeah.
Thank you.
So that was one of the questions that John posted, which I've just clicked off. But John was asking, roughly what might it cost to go through a PIRP? Are there any kind of industry standards, or there's a lot of talk here in Australia that are voluntary administration?
Yeah, I think they do have some rules that they have notified as far as PIRP process is concerned. Right. So the ordinance that was issued, so it does have certain rules there. So probably they have come up with some costs there. I have unfortunately not made an analysis on what is an average cost it could be there. But that's an interesting question. Probably I can come back to you on that if you like.
Thanks.
Yeah, at a later point of time. Yeah.
Okay, so we might have a look at the questions in the chat box. If you have a look at that, Preeti, and you can see that the first question there, asking what the panelists think of the requirement of obtaining shareholder resolution for initiating a PIRP, as well as director liability for misstatements in the information memorandum. Have you got any thoughts on that?
Yeah, because I think they have put the shareholder approval as a mandatory thing as far as PIRP is concerned. So it's a concerning thing, actually. Even I really agree with what he's trying to say there.
Yeah.
But director's liability for the misstatement, that also be, anyways, if there is a misstatement in the information memorandum under the IBC, the director's liability has to be there. I mean, it surely it stays. So it's going to be the same even for the PIRP as well.
Yeah. Yep.
Yeah.
I mean,
So I don't think there's any change as far as those two areas are concerned there.
Yep.
And especially the shareholder resolution is a mandatory thing under the PIRP. So it's here to stay.
There is a parallel with Australian insolvency law. Section 510 of the Corporations Act, which is a compromise that a voluntary liquidator can propose. That has to be approved by a shareholder ordinary resolution and then a special resolution of the creditors. And, you know, if we're focused just on the small and micro type businesses, a lot of those businesses are family businesses. And that's one of the things that the World Bank report notes, that there's a special consideration with micro and small businesses in that, you know, often we design these restructuring procedures, and you talk quite a lot about kind of creditor control and creditor tools and these sorts of things. But we need to remember that often there's a family there who's been working this business possibly for generations. There's a lot of other factors there, emotional connection with the business. And if we propose tools that are purely about dealing with creditor returns, we're kind of missing the bigger picture. As we all know, often it's the owners of the business who propose to buy the assets back from an insolvency itself, because they will often value the business assets more highly than the market does. So addressing that equity concern is something that we need to do if we want an effective tool for small business. And again, that's sorry to harp on about 5.3b, but that's something that the new small business restructuring really doesn't do, because it only provides protection for directors, for example, in the early part of the restructuring, doesn't help them once they go into a restructuring plan, and really doesn't do anything for shareholders. So that's something that's being ignored there. Now, Gausia has made a couple of comments and questions. So the first one there is about the thresholds. Can you see that, Preeti?
Yeah, the thresholds are different. Yeah, she's making a point. The thresholds are different. And since the CIRP requires a minimum default of 1 crore in the INR, it may be presumed that MSMEs related defaults would not be covered by it. That would be the only way to really so she's making a point that this is the target debtors are the MSMEs. So it may be helpful because the default for the CIRP is of the higher threshold, whereas for the PIRP, the threshold is for a low amount because it's trying to target the medium and small and micro enterprises. So that's the point she's making there. I appreciate that point. She's right. She's absolutely right. As far as the intention has been really good. Intention of PIRP has been really good. The objective has been really good. And surely the World Bank report has been very influential in motivating India for bringing in these kind of reforms, and pandemic was a trigger point, I would say. But in her humble opinion, she said, she says that shorter timelines and DIP model is really good. Of course, it is good in theory. That's the whole point I'm trying to make. Shorter timeline is good, but do we have anything in place where, I mean, they do have the timelines, but how they are going to work on that? Are there going to be any specialized courts for this one, or any specialized, any NCLTs which are going to be dealing with exclusively with PIRPs, MSME, only for MSMEs? Are there going to be some specialized courts or specialized people who are going to do this thing? Probably they think on those lines, but that's not going to happen.
Yeah.
So,
and sorry, if I can just build on that point, Preeti. I mean, you made the point earlier in the discussion about the NCLTs being overwhelmed with cases, having tens of thousands of cases. You can imagine that the numbers of micro and small businesses that get into financial distress, particularly post-pandemic, would be much, much greater than what's already there. So,
absolutely. Absolutely, Professor Jason. That's a big concern area, because the MSME is a huge chunk even under the Indian jurisdiction. There's lots of companies, although they have increased the threshold for being classified as. So with the increase of threshold for classifying a particular enterprise as an MSME, with that, more number of MSMEs are going to come. Anyway, they have increased the threshold itself. Like the earlier, for example, I'm just giving a vague example. So if a particular company's turnover is like $100,000, so they have increased the threshold by saying that no, it's not 100,000 anymore. It can be 200,000 as well, or it can be 300,000 as well. So more number of companies are going to be added in the MSME chunk, anyways, with the increase in threshold. So that's again a concerning area. Yeah. So Gausia goes on to say that a 330-day timeline like the one in the CIRP. Yeah, so the timeline, the shorter timeline here is good. That's the point she's making. And the DIIP model also ensures that the entity is run effectively during the PIRP process with the least possible hiccups. Yes, to a certain extent, it's true. To a certain extent, it's surely true. But in the long run, whether this process is going to help is the concerning thing. I mean, as long as the DIP model, DIP stays in picture and they are in control, and there can be a resolution happening, successful resolution by the appellate authority within the timeline. So that's an ideal situation. So we are unfortunately not talking about the ideal situation. We know that it is an ideal situation. It's welcome. That ideal situation, that concept is welcome. But how are they going to achieve this is the whole different story. And unfortunately, there is nothing to show that how they're going to do this. We have nothing on record to show. We have no evidence to show that how this is going to be achieved. And with other hindrances placed there in the layers of the PIRP process that we have seen in the flow charts as well, the other checks and balances, like too many checks and balances, and then there's a possibility of changing the DIP into the creditor in position at any point of time is extremely, I mean, it's like the debtor is walking on this smooth edge. Yeah. Absolutely, the company is walking on this smooth edge. It's, I mean, why would the shareholders do all these approvals only to realize that at some particular point of time, the creditors are just going to take the position, and then I don't think there is a motivation as far as the corporate debtor is concerned. That's in my opinion.
Yeah, wow. Yeah. The last question there, I'm just mindful of the time. We've just gone over 7 o'clock. The last question there is asking whether Australian insolvency law has an ARC concept. I'm certainly not aware of that. Where I've seen that more.
That's the question even I have, Professor Jason. That's the question you have.
I can imagine that there might be something like that within the context of like distressed financial institutions, kind of APRA, regulated institutions, superannuation funds, insurance companies, those sorts of things, where maybe we'd have an asset management company. I'm aware that was certainly used during the Asian financial crisis. A number of Asian jurisdictions used asset management companies. I'm aware it's also been used in China to deal with some assets of distressed state-owned enterprises. And most recently in Ireland, I know post the financial crisis when their bank, a lot of their banks collapsed, the Irish government introduced the National Asset Management Authority, NIMA, which was buying up bad loans. So I'm more familiar with that in the terms of distressed financial institutions rather than just generally distressed corporate assets. But that certainly is an interesting one. You know, a lot of these things are problems at scale. If we've got only a few thousand companies needing it, okay, we can deal with that. But you know, if we've got 100,000 companies who need it or 1 million companies who need it, then you need a more systemic solution. So that's something for us to think about. Okay, I'm mindful
so I just want to add here the Korean example you may remember, Professor Jason, the CAMCO. So they came up with some, during the financial crisis, they came up with something called CAMCO, which was the Republic of Korea. They had a public-private partnership and a bad bank emerged. So there's a World Bank study, I think, Jessio Gallarito, I can't remember the name of the person.
Jose Garrido.
Yes, so he has come up with that study there wherein he talks about the success model of CAMCO, which is quite interesting how well it worked as a bad bank. So I'm actually working more on those issues because I'm currently writing a chapter on informal rescue mechanism as well. And this is the question that I also had for you, Professor Jason. Is there a bad bank mechanism in Australia? But this draws to attention to one of your work where you, I think Queensland Law Journal, University of Queensland Law Journal, you have your article on crampdown thing, wherein you do talk about, you do write about the debt resolution, how the debt restructuring takes place in Australia. Yeah, but I can't remember if the bad bank thing was, I mean, that was a different
in the Australian context, I see that really being quite specialist for distressed financial institutions. I'm not aware that that's been used for private enterprise. Okay, so I think we might draw it to a close there. Thanks for everyone for giving up your time. Thanks for all the great questions. Thanks so much, Gausia, for all the insight that you provided in the comments and the questions.
Yes, thank you very much.
And thanks so much, Betty, for your comments from a local practitioner's perspective. And of course, thanks very much, Preeti. Greatly appreciated that. And, you know, just to give the audience some context here, I mean, these PIRP reforms have only been announced, I think, in about the last 6 weeks or so. So, you know, Preeti's had to do a bit of digging to find out some of these details. So we greatly appreciate it. Preeti, are you happy for the slides to be distributed to attendees?
Yes, I think so. I'll get in touch with you on that. I have some question, if you don't mind. I'll send you an email. Yeah, thank you so much. No problems
at all. Okay, so thanks everyone.
It was a complete pleasure.
Thanks very much. Enjoy your evening.